Welcome to the Seacrest-Wardle Premises Liability webinar series. My name is Daniel Schrode, and today we will be discussing the Recreational Land Use Act. The Recreational Land Use Act sets forth, except as otherwise provided in this section, a cause of action does not arise for injuries to a person who is on the land of another without paying to the owner, tenant, or lessee of the land a valuable consideration for the purpose of fishing, hunting, trapping, camping, hiking, sightseeing, motorcycling, snowmobiling, or any other outdoor recreational use or trail use, with or without permission, against the owner, tenant, or lessee of the land, unless the injuries were caused by the gross negligence or willful and wanton misconduct of the owner, tenant, or lessee. The RLUA was first enacted in 1953 and was expanded over time. Its general purpose is to encourage landowners to make land and water areas available to the public for recreational use by limiting landowner liability. Generally, the RLUA provides that a landowner is not liable to a person who is injured on their land if the person did not pay for the use of the land and was using the land for a recreational purpose, unless the injuries were caused by the landowner's gross negligence or willful and wanton misconduct. Historically, Michigan courts defined land narrowly under the RLUA. In Weimer v. Holmes, the Michigan Supreme Court held that the RLUA was only intended to apply to large tracts of undeveloped land suitable for outdoor use. Thus, the RLUA did not apply to urban, suburban, or subdivided land. In Neal v. Wilkes, the Michigan Supreme Court overturned Weimer v. Holmes and held that its decision in Weimer was inconsistent with the plain language of the RLUA. The court clarified that land simply means land. Therefore, the RLUA applies to any type of land. In Spores v. State of Michigan and Department of Natural Resources, the Court of Appeals further confirmed that the RLUA applies to public land. The Supreme Court recently clarified what the phrases "for the purpose of" and "any other outdoor recreational use" in the RLUA mean. Courts look to the injured party's purpose at the time of the injury, not the initial purpose for which the injured party entered the land, when determining if the RLUA applies. In Rott v. Rott, the Michigan Supreme Court made it clear that the RLUA is triggered when, at the time of the injury, a person is injured while on the land of another for the purpose of participating in recreational activities. The initial purpose for which one enters the land is not the proper focus. Accordingly, if the injured person entered the land to attend a birthday party, but went fishing and was injured, the RLUA could be invoked. The RLUA is worded to cover fishing, hunting, trapping, camping, hiking, sightseeing, motorcycling, snowmobiling, or any other outdoor recreational use or trail use. In Rott v. Rott, the Supreme Court held that the RLUA does not apply to any outdoor recreational activity and is limited to include only those outdoor recreational uses of the same kind, class, character, or nature as those specifically enumerated in the RLUA. The court further held that to qualify as any other outdoor recreational use, the activity must be one that traditionally could not be engaged in indoors and one that requires nothing more than access to the land, i.e. permission to be present and not trespassing, without needing to change it. Example: ziplining is not considered other outdoor recreational use covered by the RLUA because it requires making changes to the land. While ziplining is an activity that traditionally could only be performed outdoors, it is not an activity or use that requires only access to the land to enjoy. Ziplining cannot be performed without modifying or enhancing the land, and it is not possible to use a zipline without installing human-made ziplining equipment. Ziplining is also distinguishable from hunting and riding motorcycles, as one is perfectly capable of hunting and motorcycling without making any changes to the land, even though many hunters use tree stand or blind, and motorcyclists use tracks. A landowner becomes liable to a person who is on their land without paying the owner for recreational use if the injury is caused by the landowner's gross negligence or willful and wanton misconduct. What is gross negligence or willful and wanton misconduct? Gross negligence is defined as conduct that is so reckless as to demonstrate a substantial lack of concern for whether an injury resulted to another person. Willful and wanton misconduct is defined as conduct that shows an intent to harm, or if not that, such indifference to whether harm will result as to be the equivalent of a willingness that it does. Willful or wanton misconduct exists when the defendant has a. knowledge of a situation requiring the exercise of ordinary care and diligence to avert injury to another. B. Ability to avoid the resulting harm by ordinary care and diligence in the use of the means at hand. And C. The failure to use such care and diligence when, to the ordinary mind, it is apparent that the result is likely to prove disastrous to another. The legislature enacted the RLUA to provide immunity for landowners from personal injury lawsuits by all persons using their property recreationally, regardless of age. Thus, the RLUA even protects landowners when a minor is injured. The RLUA does not create an exception to the statutory governmental immunity provided in MCL 691.1401. Therefore, unlike a non-governmental landowner, a government entity may not be sued for personal injuries resulting from the recreational use of its property, even when the injury is caused by gross negligence or willful and wanton conduct, unless MCL 691.1401 authorizes the suit. However, if suit against a government entity is authorized, the RLUA can still be invoked. The RLUA bars any type of action, not just actions that sound in premises liability. The RLUA trumps the liability imposed by the Motor Vehicle Code. In Estate of Riley Robinson v. Robinson, the Court of Appeals held that the RLUA trumped the owner's liability provision of the Michigan Motor Vehicle Code because the RLUA was the more specific statute. In Estate of Riley Robinson, a child passenger on an ATV was injured while the ATV was being driven on the defendant's land. The defendant owned the ATV but was not driving it. Under the owner's liability provision of the Michigan Motor Vehicle Code, the owner of a motor vehicle, including an ATV or ORV, is liable for the injuries caused by the negligent operation of that vehicle. However, under the RLUA, a landowner typically is not liable to a person injured while engaging in recreational use of an ATV. The Court of Appeals, citing the long-standing rule that the more specific statute controls, held that the pointed language of the RLUA applied with greater specificity to the facts of the case and that the defendant was therefore immune from suit. Per the court, the RLUA applied when someone was injured while on another's land for the specific purpose of recreational use of a motor vehicle, in this case an ATV, whereas the owner's liability provision of the Motor Vehicle Code generally applied to all motor vehicles in all places and circumstances. The Michigan Supreme Court held that beach play is a recreational activity under the RLUA. In Otto v. Inn at Watervale, Inc., the plaintiff was injured when she stepped on hot coals in a fire pit while engaging in beach play. In determining that such beach play qualified as outdoor recreational use under the RLUA, the Supreme Court focused on the word recreational and defined that term as a means of refreshment or diversion. The Supreme Court rejected the notion that all of the listed activities in the RLUA involve or require a particular heightened degree of physical intensity or inherent risk, and held that beach play is covered by the RLUA's catch-all phrase since it met the definition of recreational. To avoid application of the RLUA, the injured person must actually pay the landowner for use of the land. In Spores v. State of Michigan and Department of Natural Resources, the plaintiff was injured while camping on public land. The plaintiff's sister, not the plaintiff, paid the defendants for the campsite. On appeal, the Court of Appeals held that the plaintiff's negligent claim was barred by the RLUA because she did not pay valuable consideration to the landowner to use the campsite. A landowner who only has a possessory right in a lake may still take advantage of the RLUA defense. In Warden Pittman v. Pincato, the Court of Appeals held that a landowner with possessory rights to a lake may still invoke the RLUA defense, even though the landowner did not own the specific portion of the lake where the plaintiff had drowned. The RLUA bars recovery to a plaintiff who hit a fallen tree while sledding. In Nash v. Duncan Park Commission, an 11-year-old boy was killed when he hit a fallen tree while sledding. The trial court granted the defendant's motion for summary disposition based on the RLUA, and the plaintiff's estate appealed. The issue before the Court of Appeals was whether the defendant landowner was liable for the death of the plaintiff when he struck a naturally fallen tree while sledding down a wooded, natural hill in an undeveloped tract of land. The Court of Appeals, affirming the trial court, held that the case was nothing more than a mere negligence case wherein the plaintiff was engaged in an outdoor recreational activity without paying. Thus, the RLUA applied. The RLUA shields against owner liability claim. In Mill v. Robinson, the Michigan Supreme Court held that the RLUA shields landowners from the liability against both negligence and owner liability claims. The case arose following the death of plaintiff's young daughter in an accident while riding an ORV owned by a defendant on his property. Plaintiff argued that defendant's negligence led to the accident, prompting the lawsuit. The court's unanimous decision affirmed that RLUA's protections extend to instances where a plaintiff alleges negligence and seeks to invoke statutory owner liability provisions. What is the impact on landowners? If a person enters your land and without paying for its use engages in certain outdoor recreational activities and is injured, you, the landowner, are not liable for the injury unless the injury was caused by your gross negligence or willful and wanton misconduct. Examples. 1. If someone crosses your land while cross-country skiing and falls, injuring himself, you, the landowner, are not liable under the RLUA, assuming the skier did not pay to use your land and you did not act grossly negligent. 2. If someone is injured while snowmobiling across your parking lot, you, the landowner, are not liable under the RLUA, again, assuming the person did not pay to use the land and that you did not act grossly negligent. Thank you for attending Recreational Land Use Act. Please contact me with any questions or comments you may have.